All right. All right. Good morning or good afternoon, everybody. Thank you for joining us today for this webinar entitled Down in Flames or Up in Smoke. Should I say cleverly titled Down in Flames or Up in Smoke, Insolvency Strategies for Cannabis Businesses. So we're going to talk today about some the issues that confront the cannabis industry, particularly through the lens of what happens when your business can't pay its bills anymore as they're coming in. And this obviously takes place in the context of an industry that has not, in California at least, and this is, we should say through a California lens, other markets are thriving a little bit better than California is in terms of the legal cannabis industry. But California's faced some very significant challenges, and we'll get into those. And as a result, there have been, and in some cases, and we'll talk about this as well, some very high profile, closures of high profile cannabis businesses within California. And because of the ongoing, quandary and tension between federal and state law, what can you do to protect your business interests? What options do you have, particularly where there is a very large cloud over the availability of one of the key tools to combat insolvency, which is bankruptcy? So that's what we're going to talk about today. And obviously, we scheduled this webinar before the news broke about the rescheduling proposal. So we had to kind of pivot and incorporate a lot of that into there. But this is not a webinar purely about rescheduling. We could have an entire webinar just talking about that. So we will touch on those topics as they relate to some of these insolvency issues, but we won't break them out completely. But we will give you a quick primer on what that means, and go over that, and then talk about, okay, what are the rules today, and what would the rules be, or what do we think the rules would be in a post rescheduling landscape? So, and we'll try to make that clear as we go through this. Today we're going to do this is the agenda for today. We're going to do an introduction of all of our illustrious panelists today. We're going to talk about the current status and the rescheduling, which is what I just mentioned. We're going to talk about how companies in the cannabis industry specifically get into the zone of insolvency and the economic pressures that have driven them there. We're going to talk about insolvency options generally. That's going to be Mr. Gupta primarily. We're going to talk about bankruptcy availability for cannabis businesses. That will be myself. Cannabis receiverships. That will be Mr. Griswold speaking on that. And then we're going to offer our predictions and then do a quick Q&A. And I should also say that in terms of economic pressures and the current status, that's going to be covered by Dana as our resident CPA. And Kim, if she can hop in, will cover both of those bullets as well. But before we go any further, I'd like to pass the mic to each of our panelists and see if you guys could go around the horn and introduce yourselves. So let's go ahead and start with Dana.
Hi, everybody. I'm Dana Boris. I'm the CEO and founder of Aura Advisors. We're a boutique tax consulting compliance CPA firm, and I've been involved in the cannabis industry since 2017. We take a very proactive approach with our clients in the industry, staying on top of both industry items and tax law changes to make recommendations to keep tax efficiency with your cannabis tax filings, but also have a defendable tax strategy in place.
Great. Thank you so much, Dan, and thank you for being here. I'll just go in the order in which you guys appear on my screen. Red, could you please go ahead and introduce yourself as well?
Yeah, of course. Thanks, Jakes. My name is Red Griswold. I operate Griswold Law locally in San Diego, and I act as a court-appointed receiver as well as a court-appointed partition referee across the state. And a portion of our practice has recently dealt with taking over cannabis operations as a cannabis receiver. So certainly going to want to focus on that experience and talk about a few case studies today. But in general, yes, get appointed often in business disputes, real property disputes, health and safety matters, as well as partition disputes. So looking forward to the talk.
Thank you, Red. And last but not least, Mr. AJ Gupta, my partner in crime and in law. Could you please introduce yourself?
Yeah, so I am a bankruptcy specialist. I'm one of a handful here in Southern California, in San Diego. My practice does a lot of bankruptcy and dissolution work. We also do a ton of litigation. So But we have a fair amount of experience between Jake's cannabis issues and my bankruptcy experience dealing with bankruptcy insolvency issues as it relates to cannabis businesses.
All right, thank you, AJ. And last but not least, I am Jake Ayres from Gupta, Evans and Ayres. I'm going to be your moderator. I'm also going to be presenting briefly on the bankruptcy in the cannabis realm portion of the program. My practice focuses on, in terms of the cannabis industry, doing business litigation within the cannabis industry. I also have a practice outside of that doing real estate litigation and land use litigation and counseling. And of course, those issues often can and often do overlap with the cannabis litigation because it's so heavily regulated and zoned. So that in a nutshell is my practice, and I'm excited to get going. So without further ado, I'm going to go ahead and move on to our next slide here. So I wanted to start off by talking about the rescheduling proposal. So, generally speaking, and I'm sure everyone has heard this news. This is a very, very, very big deal. Although there's different schools of thought on that, and we'll get into that. So Dana, if you wouldn't mind, could you take us briefly, give us a bird's eye view of what has been proposed and what it means?
Sure. Yeah. So this proposal is to move cannabis from Schedule 1 to Schedule 3 under the Controlled Substances Act. And from an income tax perspective, this is absolutely huge for our clients and for cannabis taxpayers, or anyone for that matter, who's considered trafficking in a controlled substance and subject to Internal Revenue Code Section 280E. So Internal Revenue Code Section 280E disallows anything that's not considered cost of goods sold. So this could be sales, marketing, general and administrative expenses, or even some indirect overhead costs. So if this proposal goes through and cannabis is rescheduled, it would mean the elimination of Internal Revenue Code 280E for cannabis companies.
Precisely. And you beat me to the punch a little bit, because I think that, in my 2 cents, is that is the biggest immediate impact. There's a bunch of other less tangible impacts, but in terms of the day-to-day dollars and cents of cannabis businesses, I think that is the largest impact. But taking a wider view, and this would be, the Kim Sims portion of the program, but I'll try to summarize what she would say. And that is that this is a really big deal from a policy perspective. And it's been everyone, and this is one thing that's kind of an interesting bipartisan issue, is that, cannabis has been scheduled alongside heroin and PCP in Schedule 1. Some of the worst in terms of, drugs with very negative outcomes and side effects and what have you. So this is moving it down to Schedule 3, which is in the same schedule as Tylenol with codeine. So it's in much more of where it probably should be and should have been for the last, 30 years or so. So, and I also put in timeline, because what has happened now, and this is just to kind of finish this up, is what's interesting is that normally the DEA would be proposing this rule change. But if you read some of the news that's been leaking to the press about this, it's actually the DOJ. So the DOJ has been pushing this forward, and the DEA is kind of pushing back. So I think there might still be some sparks there, where the DOJ is trying to push this through as a policy objective. And the DEA, being the DEA, was made a lifetime out of enforcing these rules against cannabis, heroin, and PCP alike, are probably going to be resistant to this change and this diminishment of their authority. So point is, the timeline is that there's going to be a public comment period. And then after that point, there's going to be a final rulemaking. And because the DEA is not necessarily on board with this, there might be some hiccups in this process. So as much as we're all optimistic about this, this is not a final rule. This is a proposal. So keep that in mind as we talk about this, that this is still up in the air. It's likely to come down, but it may not come down exactly as we think it will. So,
I'm sorry, and I know I'm not supposed to be asking the questions here, but Tylenol codeine still requires a prescription.
So that's part of the issue, right? is that, and we'll talk about that. This is this slide. So long story short is that that's one of, and we'll get to that on the next slide, is that one of the fears about this is that this is going to be, we'll get there, AJ. So we'll hold that thought. So this is just a will and won't for what Schedule 3 will and won't do. This was lovingly prepared by Kim Sims. And you can see that third bullet on Schedule 3 will is the major tax relief, is what Dana was speaking about. The other stuff is more of the intangibles, is that this is the incremental reform that helps provide some legitimacy. It puts cannabis probably where it should have been forever in Schedule 3, rather than as part of these very virulent controlled substances. But the other thing is the other things to keep in mind is that what it won't do, which is that it doesn't legalize it. It's to your point, AJ, it doesn't necessarily mean that it's freely transferable between willing buyers. It's still a controlled substance, e.g. Tylenol with codeine. It doesn't open the door for interstate commerce. It doesn't resolve the inconsistencies in cannabis regulations. It doesn't fully resolve access to banking, although I have some thoughts on that. It also doesn't do anything for criminal justice reform. So there's still a lot left undone by this. And that's why I think Dana is right to focus on the tax relief portion of the program, because that's tangible. That happens as soon as this gets adopted and gets rescheduled. The 280E ban on business expenses deductions goes away. And I kind of put this in broad strokes, and honestly, this is really summed up by seeing people that are way smarter than me debating this on LinkedIn. But that's basically what this is. And I'm happy to hear other panelists' thoughts on this, but I think the way this gets summed up is some people are fearful that this just paves the way for big pharma, for lack of a better term, to gobble everybody up and turn this into a pharmaceutical industry regulated like a pharmaceutical, to your point, AJ, that it would be a prescription based. Other people are thinking, well, you know, cannabis has been Schedule 1 for a long time, and the feds have largely allowed non-bad actors to continue operating as they have been, as long as they're in compliance with state law. And that might continue, even though there's theoretically these more pharmaceutical-based regulatory ideas. So, and more importantly, it's also possible that like it's a pressure release. You finally get to claim the benefit of your business deductions, and that might lead to some positive further consequences. But I'm happy to hear if any of the panelists have any thoughts on what this means and whether you subscribe to either of these two schools of thoughts, or if you think there's a third or fourth or fifth one. I am all ears.
Yeah, I think it's mainly the banking issue, right? I think it makes it more likely to become bankable and investable, because that's I think the biggest issues that the industry faces right now from my chair is that like getting investors to know that they can legally deduct certain things off of a legit cannabis business, and that they can go to a bank and see what's going on with the business. You know, they're not literally getting bags of cash on their doorstep every week. I think that makes this, that's the key to, I think, solving a lot of the challenges with the industry.
Right. And again, AJ, you've leapfrogged my slide here, but I appreciate the thoughts. Dana, Red, do you have any thoughts on what this kind of means for the industry?
I mean, to me, for the tax perspective, income tax perspective, it keeps people out of potential bankruptcy, going out of business. We've had a few in the last couple of years that weren't able to keep up because of increased costs, because people wouldn't work within their cannabis, or it costs more to work with those certain providers that would, and just taxes alone just absolutely crush them when they're paying tax on a gross margin level that is just completely absurd with what their net profit is of the business. So if it passes quickly, I think that provides very needed release of pressure, like you mentioned.
Right. Red, any thoughts?
Yeah, I'd just really be echoing what Dana just emphasized again. And from a more maybe practical level, from my perspective as a receiver, is that any financial relief, like we're talking about, release of this pressure on the legitimate cannabis industry, I think is going to have a positive effect on um, avoiding many of these licensed cannabis operators from slipping back into the black market where they can
Okay,
make
yeah.
money. So again, if this is able to provide a bit of relief on the financial constraints of federal, state, and local taxing agencies, this could be helpful.
Right. And each of your responses have touched on each of the pressures, the major pressures that we've identified on this slide here, which is the lack of banking access, competition with the black and gray market, and then taxation. So you guys nailed that. So I can skip this slide as much as I love the talking heads gift that I put on here. So, and you've also summarized this slide as well, which is, the arguments for how rescheduling might lessen the impacts of these challenges, which, and AJ, to your point, right now there are banks that bank cannabis businesses, even though it's currently Schedule 1. And the bankers that I've talked to have said, the first thing that I come up with is, well, aren't you guys federally insured? How do you get around that? And one banker I talked to said, the FDIC, all they care about is a liquidity crisis. So while on paper, they might theoretically care that, you're banking a federally illegal business that's deriving its profits from federally illegal substances, their priority is more about avoiding a 2008 or First Republic scenario where you're running out of cash and you become in need of a bailout. And as a result, it's really just about risk management for these banks, and they have to decide whether the juice is worth the squeeze. That's at least my impression. And Dana, I'm sure you've probably run into these issues, but my opinion is that if banks are already willing to bank cannabis businesses at Schedule 1, going down to Schedule 3, I think would only increase the likelihood that more banks are going to throw their hat in the ring. But Dana, do you have any thoughts on that?
I agree. I think we'll see more banks come online. Just informally, I've talked to people who are bankers at some larger institutions, and they've already hinted they're creeping into the hemp right now,
Right.
so that they can set the
Baby
stage
steps.
for launching cannabis. But I do still think the lead time to open the bank account is going to be long, like it is right now because of all the compliance. And I still think the costs will be high.
Yeah.
Where they're charging percentage of deposit. And so you're still forcing people to have a lot of cash, right? So I still think it's not going to solve everything.
Right. And to your point, every banker I've talked to, when I ask them about, okay, what do you look for when you're looking to whether you want to take on a cannabis client as a banking client, they say, well, I need to see a certain amount of cash on hand. I mean, that's really what they look for. It's a very black and white approach, and it helps them. That's the one thing that's solid that helps them mitigate their risk. And to your point, we've talked about this already. The removal of 280E, that's the most straightforward pressure release we're talking about here. And to Red's point, is that the rescheduling, if it reduces the tax burden and theoretically increases access to banking, it makes them leaner, more streamlined, more efficient. And that way their pricing means that they can stay afloat and compete with that black and gray market. Whereas if they didn't have that relief, they might go belly up. So I think that's another way of looking at the potential for impacts of rescheduling. So one of the things I wanted to talk about, those are the pressures on the cannabis industry. Now we're going to kind of shift into the zone of, all right, now we're in the scenario of, okay, what happens if you've passed the point of no return and you want to think about your options as a cannabis business? You've become insolvent, can't pay your bills on time. What do you do? So one of the first bedrock principles we want to look at is, in any insolvency scenario, the first question from your lawyer or from your accountant, your receiver, is going to be, what are your assets? What is your asset picture? I'm tempted to pass the mic again to you, Dana, here, because you're as a CPA, you've probably had these types of conversations. So I listed a handful. Feel free to freestyle on those or go off script, but could you take us through what are the typical key assets of a cannabis business that's considering dissolving or a sale or bankruptcy or or receivership?
Yeah, so first thing we see is whatever inventory is left over that they have not yet been able to sell. We see licenses, all of the cannabis licenses that they're required to have. They may own land in the building, maybe in another entity, or they may have put in significant leasehold improvements into that property. There's also the IP, right? So the brand name, the logo, customer list, recipes, formulas, processes, all of that. And then from a tax standpoint, even if they weren't profitable, they may have net operating losses. So it is an asset, so to speak.
Right. And let's see if I just promoted Kim. She just hopped in, so I'll see if she has anything to say on this. Because I know we've talked about this. Hi, Kim, how are you?
Hi, everybody. Let's see. Well, I'm just jumping in.
Yeah,
Did we
sorry
talk-
to ambush
So
you.
I'm so sorry, everyone. Did we chat about, the transferability of licenses in terms of local and state?
Not yet. I was hoping that's exactly what you could chime in on.
Great. Again, my sincere apologies. So, one of the things that is critical in the cannabis space is understanding, what your company owns and how it is held. And in the cannabis world, it is a dual licensing process, which first requires local approval. And every city and municipality gets to decide how they want to regulate cannabis, if at all. Sometimes it's a simple land use process, like here in San Diego, city proper, you can get what's called a conditional use permit, and then the owners of the business, which runs with the land, which is so that really inures to the benefit of the property owner. And then an operator's permit that basically states who the owners are. But lots of other cities have a merit-based application or lottery system, and then the entity ultimately holds the asset, and then the local government is going to tell you the who, what, where, when, and why in terms of if you can transfer your license. So some cities actually don't allow a transfer of license at all. So, for example, if you're looking at the city of LA, you're more or less stuck with the entity based on how the DCR, their cannabis licensing unit, licenses. So if you have a company that's looking to sell its license, but the entity that holds it is encumbered with debt, that's going to be problematic because you can't just say, okay, well, we'll just purchase the state license then. First, you have to have your local approval. City of Lompoc is another one where there is no transferability of that local license. So you've got to know what you're buying. In a city like that, it may be really ultimately that you're going to be paying to have the lease assigned to you, and then you have to apply for the local license afresh. So again, every city and county has its different rules. You may only be able to transfer a certain portion of the entity's equity. So for example, if you're looking at a city like Corona or Oxnard, you might ultimately have to have like multiple closings depending on how much of the license you could transfer at a time. And so again, when we're saying, transfer of the license, right, that may be the entity that owns the license, or it might be the local license. So again, we're looking at what exactly is being sold, or what exactly is being auctioned off in the receivership. That's another interesting one. When we dive into that, I've got a fun example going on with that right now. And then you can do your transfer at the state level. It's a little bit easier, but there again are certain trigger points. So transferability is really highly dependent on the rules of your local government. And before anyone sets up any transaction, for me, the first piece of diligence I always do is I dig into that municipal code and I figure out, how am I going to structure this deal in a way that comports with the local regulations? And then I can always make it fit into the state regulations. But it's really critical to understand the rules at the local level.
Thank you, Kim. I appreciate you jumping in and hitting the ground running. So thank you. So moving on. So now that we've got a better idea of the types of assets in a cannabis company, whether insolvent or not, and we're in the scenario where, okay, you're considering your options, you can't pay your bills anymore, you're kind of spiraling, what are your options? So I'd now like to kind of go through the legal options when you confront insolvency generally. And for this, I'd like to ask AJ to take us through these general broad strokes options. And if you could talk to us about and tell us about what scenarios fit each option.
Yeah, and it's a good segue because, and I don't know how in depth we want to go into this, but I do want to talk a little bit about transferability of licenses and how that impacts your approach. So the first thing that you're going to think about when you're talking about any type of insolvency event, dissolution, or bankruptcy is valuation. And when you think about valuation, you're thinking about it in terms of two different types of valuation. One is a liquidation value. And you have to look at what the assets of the company are and what the liquidation value of those assets are. We've all moved and sold furniture. We know what that looks like. It's not good. The other way that you look at a valuation is what we would call a going concern valuation or a present value of future income stream valuation. And this is where the transferability of licensing becomes very, very important. Because if you think about an insolvency event or the transfer of the assets, if you're going to transfer the shares of the company, the debt is going to go with it. All right. And if the debt goes with the transfer of the asset, then the new owner is going to have the same problem that the original owner had, and that they're still upside down and insolvent. So where you have a case where there is the license can't be transferred and you're essentially just only able to sell the shares of the entity in order to transfer the business, the new owner is just as bad as the original owner. And it makes the fair market value somewhat irrelevant, quite frankly. And the only option at that point is either a Chapter 7 or a dissolution, which I'm using interchangeably. One is a state court process, one is a bankruptcy process. Okay. But the other way that normally a business, when they approach this point of insolvency or are insolvent, is they would say, look, what if we sold this as a going concern? And we say, what is the value as a going concern? And what's the fair market value? We find a buyer, we sell the company for fair market value. We use the proceeds to satisfy creditors to the extent that we can. And the balance, either they go after the personal guarantees or is simply not collectible by the person that issued the debt. So that's a typical Chapter 7 or dissolution process. And it starts with this issue of the transferability of licensing. The second thing that we look at through the bankruptcy lens, and Jake's going to talk a little bit more about like what it is in terms of the what options may be available to different types of companies in bankruptcy. But even the bankruptcy analysis starts with both a liquidation valuation and a fair market value valuation. And both are important because essentially what a restructuring says is, look, we're going to give you more through this bankruptcy process than you otherwise would receive if the assets were sold or liquidated. And both are, it's somewhat nuanced as to which value you use, whether you're using a liquidation or a fair market value valuation. And it has to do with the amount of the secured creditors and kind of this balancing of interests test. And I don't want to get into that, but both relate back to the transferability of the licensing. If there is no transferability of the licensing, the only valuation that's available to you is a liquidation analysis. And you would start by saying in a restructuring, we can only restructure through a liquidation analysis. The liquidation value is 10 cents on the dollar. So therefore, as long as the creditors get more than 10 cents on the dollar, then I'm going to propose a plan that pays them their 10 cents on the dollar, plus maybe another X percent on top of that. And then the balance of this will be released or discharged. That's what a typical restructuring looks like. But both questions start with evaluation, which start with the issue of transferability.
Right. And to that point, AJ, let's say you're a cannabis business, you're insolvent. Does that mean the only or one of the few scenarios in which bankruptcy would make sense would be if that license is transferable?
Not necessarily. I mean, if you're the owner of that company, a restructuring might make sense under the liquidation valuation because the liquidation value is going to be much, much lower than maybe a going concern valuation. So whereas a going concern valuation might be, 30 to 40 cents on the dollar as a value, a liquidation might be 10 cents. So if your restructuring plan only requires you to pay, let's call it 15 cents on the dollar, that's way better off than you would otherwise be under than 35, 40, 50 cents on the dollar. Does that make sense?
Yeah, I guess what I'm driving at is because I've heard you give this spiel in outside of the cannabis realm, which is, that bankruptcy often isn't the right choice to close your
Right.
business's doors, right? So in what scenario would it make sense to consider bankruptcy or consider chasing it as a cannabis business?
I rarely will file a Chapter 7 dissolution unless there's a very good reason for me to do so. And I know that the books are extraordinarily tight because it creates a tremendous amount of exposure for the principals.
Right.
So bankruptcy appoints a single trustee who is very skilled at chasing down anything that may be improper with your books for a period of 4 to 7 years. And so unless you've got, a third party auditor that is looking at the books every year and knows that every penny is accounted for, I will not file a cannabis Chapter 7. There's no planet where I'm going to do that. I would use the state court tools for dissolution, where we would simply go through the process. We'd notify the creditors, we'd liquidate the assets, and we distribute in accordance with whatever the distribution plan, whatever the distributions would call for.
Yeah.
Secured creditors, taxes, employees, so on and so forth.
And broadly speaking, when would you consider a Chapter 11, whether cannabis or non-cannabis? I mean, could you describe like what scenario where that would make sense?
The first question that you always ask is, if this company had no debt, could it make money? Because some people walk in, they're like, "Oh, I've got a lot of debt, and I can't. I've got no operating income, so I have to restructure." And I would say at least 50% of the times when you look at these, you look at the debt service on the company, that's not the issue.
Right.
9 out of 10 times, these companies simply are not profitable. So I'm looking at, what does this company look like without debt service? Is it profitable? Will it support the cost of the bankruptcy along with a reasonable repayment to creditors? That's a step one analysis. Step two of the analysis is always valuation. And again, I'm looking at secured creditors, unsecured creditors, liquidation value, and fair market value. And those are not always easy questions to answer, but you can do an armchair valuation based on profitability. You can do an armchair valuation based on liquidation, and you can have an idea in very short order as to what a restructuring looks like.
Right. All right. Well, thank you, AJ. And to that point, I'd like to segue into a nice little case study we've been presented with, which is the MedMen, which, and we'll get to it, has fallen on hard times. And it started out as MedMen, and you may have noticed, they were very ubiquitous early on in the illegal cannabis market in California. And, sometimes termed the Apple Store of weed or something along those lines. They were, in fact, everywhere. Then all of a sudden they started disappearing. And this is what happened. So in January of this year, the MedMen just went into a free fall. And what happened was initially they had flown too close to the sun. They were spending way more money than they were making, and they had to decide what to do. So what they did in early January was that they just started doing a restructuring, which practically speaking meant shuttering the majority of their stores in California. And this is a story from the media that says that, and I've got a couple of key excerpts here. And it says, currently MedMen stores remain open, including its 8 LA area locations. But I think even at that point in time, they had closed everything else. And I think they have closed that since then. And there's also a story here about how they were returning to WeHo after its stock plummeted and everyone resigned. And there's a little nugget here for exactly what we're talking about, which is ineligible for bankruptcy due to federal regulations against marijuana, has been restructured by operator Captor Retail Group. So that's what happened in early January. Now, 3 months later, this is what happened. So 3 months later, April 26th, they went a completely different direction. And this is exactly the types of considerations we're talking about. They went from trying to salvage it without dissolving, without going into bankruptcy, without going into receivership. And then after 3 months of trying to hack it, they realized they couldn't do it. And they ended up declaring bankruptcy in Canada because, of course, in Canada, it's federally legal there, nationally illegal, and starting a companion receivership in Los Angeles Superior Court. So they tried to do a belt and suspenders approach after trying to do a restructuring. And we can only, imagine what decisions went into that. But I think we all kind of have a general idea. I think they tried to salvage what they could and then realized that they, couldn't really make it out. So that's kind of a potent example of what types of decisions you have to make in this industry, given the pressures and lack of availability of insolvency options because of the current legal regime. So speaking of bankruptcy and the hinted at inability to declare bankruptcy, so the question is, can I declare bankruptcy? And the answer is, if you have a cannabis business, and the answer is it depends. It's the most lawyerly answer of all time. It's so annoying, but it's the answer in this case. So I will breeze through these because I know we've got a lot of ground to cover with Red, and I still want to make time for Q&A. But long story short is that it is a sliding scale. And just because there is a cannabis business and just because cannabis is federally illegal does not automatically prohibit a debtor from bankruptcy relief. And the important thing to note here is that these are all rulings from the Ninth Circuit, which of course, I think even we as practitioners in California can acknowledge is notoriously liberal on a lot of issues. We don't, and so there's different rules in different circuits, but this is pretty limited. This discussion is limited to the Ninth Circuit, which of course encompasses California, Nevada, Arizona, Washington, Oregon, Alaska, and Hawaii. So some very cannabis friendly jurisdictions in there, of course. And it's a sliding scale. The closer you get to cannabis proceeds, the more likely you already have your petition dismissed, because U.S. trustees who are always notified and are representatives of the U.S. government often don't take kindly to these types of bankruptcies because they're saying you're asking the bankruptcy court to administer illegal assets. We can't, that's not permissible, therefore it should be dismissed. And we'll get into the nuts and bolts of that in a second. But generally speaking, it's a continuum related to proximity to the illegal proceeds or the proceeds of the federally illegal product. And of course, as a caveat, when I say illegal, I always mean federally illegal. So here's the stumbling block. So this is what I was just referring to with the motions by the U.S. trustee. In bankruptcy, you can get dismissed for cause. And cause is a legal concept in the bankruptcy code that has a lengthy definition, which I won't get into, but it's a very malleable one and it's a non-exclusive definition. However, as we'll see in a moment, illegality is not one of the listed reasons for cause. The other places where you can stumble in chapters 11 and 13, where you have to propose a plan of reorganization or a plan of repayment, one of the requirements in the bankruptcy code for both of them is that it has to be proposed in good faith and not by any means prohibited by law. So the Ninth Circuit, again, as we hinted at before, is relatively liberal. They've taken a very literal interpretation of this to kind of make some breathing room for these types of debtors. And that is, they're parsing that phrase to mean, was it proposed in a non-illegal fashion, not whether the plan itself requires any illegal activity. So you can hop over that plan confirmation phase based on this case from the Ninth Circuit, which is now binding on all of the bankruptcy courts and all of the district courts, because it's this interpretation. Other circuits, the 10th Circuit, which encompasses Colorado, says the opposite. It says, no. This is not whether it's proposed by any in good faith and not illegally. It's whether the plan itself incorporates any illegal terms. So it's a lot harder in circuits outside of the ninth to get your plan of reorganization or plan of repayment under chapters 11 and 13 confirmed. You can also get dismissed for abstention, and that's a more catch-all term. If the interests of the creditor and debtor better served, you can get dismissed. So there's a whole host of ways where your bankruptcy can go awry, even if you think you can fit through that eye of the needle where, hey, we're not that close to the cannabis proceeds, so we should be able to declare bankruptcy, take advantage of the automatic stay, and go through that process. So the general rule of the sliding scale was more or less reaffirmed in a relatively recent case of Enre Hacienda. And that's where, this is where the U.S. trustee brings the second motion to dismiss after losing one time before. And the unique facts of this case lead the Central District of California to deny that motion to dismiss, because really all the debtor wanted to do was liquidate its main asset, which is stock in a Canadian cannabis company. They weren't doing any ongoing cannabis activity. They just had this big fat asset that was worth a decent chunk of change, and they wanted to sell off that stock to pay off their creditors. And the U.S. trustee filed a motion saying, listen, this is still asking the court to administer the proceeds from a federally illegal business in the United States, even though it's a Canadian company. Therefore, it should be dismissed for cause. The court says no and says illegality on its own is not enough. It's not listed in the examples of cause. And more importantly, this results in the best outcome for all the creditors. All they want to do is sell off this stock. It's not going to require any ongoing illegal activity apart from the liquidation of the stock. Therefore, we're going to allow it to go forward. And in so doing, they analogize it to the PG&E bankruptcy and the Enron bankruptcies, saying that engaging in illegal activity is not necessarily a deal breaker for the bankruptcy court. The bankruptcy court is not, their role is not to enforce the criminal law. Their role is to manage bankruptcy estates, assets, and in order to satisfy creditors and administer the bankruptcy estate. They are not administrators of the criminal law. So it's a very interesting approach. And more interestingly, they also have a backup rationale saying that, hey, even if we were to find cause, the unusual circumstances exception of 1112B2 would apply. So, and I think that's really where the daylight is in that case. But moving on. So this is the questions you have to ask yourself if you're a cannabis business considering bankruptcy. Does it require the bankruptcy court to administer cannabis assets proceeds? Is the plan of repayment reorganization viable without or dependent on cannabis assets or proceeds? And is the debtor directly engaged in violations of the CSA? So sometimes, and there is at least one case where it says if you're an individual debtor, but your company is the one administering the assets, sometimes you can get away with, having your getting over a motion to dismiss your petition because the company is the one doing it, not you. It's one step removed that sometimes bankruptcy courts look on it a little bit favorably. And last but not least, so now the question is, what is the impact of rescheduling, potential rescheduling on bankruptcies? And the answer is that it does, as we established on our earlier slide, it does not equal legalization. Therefore, the arguments of the U.S. trustee to dismiss for illegality are not going to go away. They're just going to be weakened in force, in my opinion. And similar to the banking analysis, if bankruptcy courts were already finding a way to greenlight certain attenuated cannabis bankruptcies when it was Schedule 1, I think that once rescheduled to Schedule 3, I think courts are going to be even more lenient towards certain cannabis bankruptcies. In other words, the sliding scale gets slidier. That was the best term I could come up with here, is that because of that rescheduling, courts are going to be allow businesses that are closer to touching the plant, so to speak, the green light to go forward and to get over that. And more importantly, Hacienda opens the door to that unusual circumstances. A bankruptcy court could say, well, yeah, there's cause to dismiss here, but the unusual circumstances are that this has been recently rescheduled. It's this company's in the process of getting regulated by the DEA and getting their proper permits in place. Therefore, we're going to allow this bankruptcy to go forward and deny the motion to dismiss. So I really try not to take up a lot of the airtime here, but now we want to talk about the alternative, the state law alternative to cannabis bankruptcy, and that is receivership. And of course, we just saw that come into play with the MedMen Canadian bankruptcy and LA receivership. So with that in mind, Red, can you take us through just the general contours of, you know, some of the things on the screen as far as when is the receivership the right fit for a cannabis business?
Sure. Yeah, and I'll even take quickly even a larger step backward to
Sure.
kind of introduce, the receivership remedy as a whole, and just kind of generally speaking, a receivership is going to be implemented for the purpose of a receiver to step in and preserve the status quo of whatever assets in dispute, whether it's business, piece of real property. And so it's trying to minimize loss, minimize damage to the asset, and preserve that status quo while the parties, of course, are litigating and getting to some sort of resolution. And so now, kind of referring back to some of the slides and the topics we've been discussing, when you think about what kind of assets are at issue with the cannabis business, one that jumps out at people is inventory. Well, for that asset and that inventory to be liquidated, monetized, etc., for the purpose of some sort of cannabis entity in a receivership, somebody's got to sell it. Somebody's got to sell it to liquidate that into cash, and that's got to be there's got to be a vehicle available to obviously state court and not the bankruptcy court. It's got to be a vehicle for some representative on behalf of this entity to make a legal sale of such assets to actually provide some value to the receivership estate. So I say that to say that it's typically looked at for receivers to simply preserve the status quo. But when the objective is a creditor-debtor dispute, potentially a partnership dispute over mismanagement of the cannabis entity itself, the receiver is going to be stepping in and getting his or her feet very dirty in the actual operation of such business. So this is where it becomes very, very clear why, even though the scale is getting slidier, as Jake put it, we are still way outside the bounds of allowing any sort of bankruptcy trustee getting as involved as a receiver does on a very kind of logistical perspective. So what's a good cannabis company? What would be a good fit for receivership? It all starts, just as AJ was talking about the assessment for any business that's having insolvency issues. It's the same thing from receivership. A court is going to look at the assets that the cannabis entity is in control of, and it's going to be deciding, well, what can a receiver really do here? How can a receiver or the receivership remedy resolve the disputes at issue? Usually it's people with their hands out looking for money. So can a receiver help? And so the aspect is going to be, it's going to be looking at those assets. What could a receiver do lawfully to step in and resolve some of these disputes? In California, Department of Cannabis Control, with their kind of regulatory framework, they envisioned a receiver being the type of third party that would potentially step in and be in control of a licensed cannabis operation. So it cites to receivers as an individual who would need to give notice when there was some sort of operational control change. And so that's exactly what a receiver would do: step in, give the appropriate notice to the state agency, obviously get in front of any sort of taxing, reporting, track and trace, any sort of issues or hurdles that have popped up before the receivership was put in place. The receiver is going to be front and center with that state agency, in addition to, of course, all of the disputing parties and creditors involved in the case. But again, back to that threshold question, you need assets. You need assets that actually can be liquidated to satisfy concerns of the parties. Or in the going concern route, a receiver and a court need to be convinced that having a receiver step in operationally and to take over control of the operation and maybe remove certain folks from control of the operation, that there's some value there. It's going to be very costly, but if there's some value there that the operation can be saved or restored. The operation and some of its assets can be sold to a buyer, and then ultimately, obviously, those funds to liquidate and satisfy certain claims. That's where a judge is maybe going to entertain the idea of appointing a receiver. But appointing receivers, lots of different phrases are used, one being that it's a drastic remedy. So judges are very cautious and think long and hard before appointing a receiver on any case. But when you start talking about cannabis entities, the litigators involved have to make a very strong, informed advocacy push to get a receiver appointed over a cannabis entity in California. I know we're a little short on time.
Sorry,
so
I honestly did not
Yes.
mean to click. Yeah, continue.
No, that's fine. I would also just say I'm kind of wrapping in a lot of the connected points we already talked about. But something AJ brought up, going into state court with a dissolution cause of action. Many times, state court is certainly more informal, we'll say, flexible within this kind of equitable remedy of a receivership. And you see that specifically with cannabis receiverships in the form of a receiver, in a sense, sometimes steps into the role of, they might put on their hat of actually operating, let's say, a dispensary and putting in court-approved management to run that operation. And at the same time, maybe later in the case, they're going to be, in a sense, somewhat of a liquidating agent, carrying out the dissolution remedy through a sale or simply liquidation of assets. So it's a very nimble tool. It is, at least for now, one of the obviously only options for a struggling cannabis business to address insolvency through the court system. But receivers and the receivership remedy as a whole in California are watching closely to see what happens next.
All right, thank you, Red. And with that note, I know we're running short on time, but I'd like to go around our panelists and just ask, what do you all think is next? Both in the context of, insolvency and outside of insolvency, given the rescheduling news. Because I know that I get asked that all the time. So I'd like to pass it off to each of you. So why don't we start with you, Dana? And what do you think do you have any predictions for what's next?
Yeah, so clients right now are obviously asking, what does rescheduling mean for them from an income tax perspective? So once if this is, rescheduled, then 280E will go away on a prospective basis. But what about retroactive? What about all the years of filings and all the outstanding taxes that they owe or taxes they pay? What happens with that? That's a big question. So we're working with our clients who may not have a true leave budget to pay $100,000 plus for a tax opinion plus possible litigation costs, is filed protective claims of refund, which is not an amended return. It's a protective claim to keep your statute of limitation open, saying that 280E doesn't apply. So you do that. It doesn't put the person signing it under penalties of perjury. You disclose the position. It's processed if this becomes retroactive. So that's what we're suggesting.
Gotcha. Kim, do you have any predictions from your side of the fence?
My goodness. Well, after 15 years serving this industry, I've learned better than to make any predictions. I think the question that I'm getting asked with the most frequency is, I guess there's two. One is like, how quickly is this going to happen? Because as Dana, I'm sure, has touched upon with the elimination of 280E, that's going to create more cash flow for companies. So, so the first question I get is like, when is this going to happen? And I think the reality is that we have a ways to go. The rulemaking process and likely to head to an administrative hearing, which can work much like an actual trial. And then, an aggrieved party can file a lawsuit. We've already had groups come forward and say that they'll absolutely challenge this. So I guess, I think that there's hope, but it's not going to be immediate relief the way that I think some people are hoping. And then the other question I get most frequently is, should I bail, or is now the time to double down with some of these changes on the horizon? And, maybe even what I hope perhaps could move more quickly would be congressional reform. And this rescheduling announcement has certainly put some fire in that. But I think if you can hang on a few more years, which I know is asking a lot, I think there could be a light at the end of the tunnel. I don't think it's going to be this like multi-million-dollar, everyone's living the, luxurious lives. But I think, again, we're seeing so many distressed assets, so many people who thought these changes would come sooner, and they weren't well funded enough based on, predictions of when rescheduling or descheduling would happen. So again, I think if my advice is, again, if you've got the cash flow, if you can hang in there a few more years, I do think there's a light at the end of the tunnel, but it's not something that's going to happen overnight. And people really need to continue to manage their expectations about how quickly some of this change will take place, and it's how quickly it will impact the bottom line of the business. Those are sort of my closing thoughts based on, again, just the things that I'm hearing and the questions I'm being asked by my clients.
Right. Red, any thoughts from the receivership angle?
Yeah, I would, continue on with Kim's thoughts of having hopefully a hopeful message out there and approach. I guess just going off the idea of people I talk to and such, is that I still get lots and lots of calls. I do a lot of health and safety receiverships, so I work with a lot of cities, city attorneys. I would love the day that the number of black market illegal operations would finally feel the other side of this pressure and be minimized and pushed out the back door, because these lawful operations can actually operate to a bit of profit. So any sort of relief that we're talking about in this rescheduling from a tax perspective would be welcomed. And I know even from that kind of unique perspective of cities and trying to regulate the black market operations.
Right. Yeah, well, thank you all for your thoughts. And I know we're a little bit over time, but I wanted to open it up to questions if there's any in the audience. So I will open it up and see if anyone has any questions. I know we had some folks that had to leave, had a hard stop at 1, so we may not have any questions, but I at least wanted to open the floor. So if anyone wants to chime in, feel free to do so in the chat or the Q&A. But all right. It looks like we may not have any questions today, but I think I want to thank you guys all for coming today and participating in this discussion. Obviously, there's so much more we could talk about, particularly because of the rescheduling news. But I appreciate you guys kind of keeping it cabined to the insolvency discussion, and I'm sure we'll have more conversations in the future, public and private. But thank you all for being here, and we'll make this available. I recorded this webinar, so we'll have this available to us after the fact. So thanks again for everyone for being here, and looking forward to seeing what the future brings for this industry.
Thanks, Jake. Thanks, everyone.
Jake, thank
Thanks,
you.
Jake.
Thank you, everybody.
Thank you.
Bye.